August 2010, in a strip mall parking lot in Houston, Amy Albritton watched a police officer drop a crumb from her car floor into a vial of pink liquid. If it stayed pink, she could go home. It turned blue. He held the vial up in front of her face and said 2 words, "You're busted." She was not driving. 9 hours later, she was booked into the Harris County Jail, and inside 2 days, she had pleaded guilty to felony cocaine possession. But the crumb was not cocaine. It wasn't a drug at all, and the state's own laboratory would prove it 6 months after she had already confessed to it in open court. In one American county, 212 people were convicted the same way she was, on evidence a laboratory later found was not a controlled substance at all, and the $2 kit that did it is still in patrol cars across the country tonight. Houston, Texas, late afternoon, August 2010. Amy Albritton managed an apartment complex in Monroe, Louisiana. It was called Francis Place, a well-kept brick building, and she had run it for 2 years. The job came with an apartment. Hold on to that, because it means she did not have a job and a home as 2 separate things. She had one thing, and it was both. She had 2 sons. The younger had been disabled from birth. Her mother, a pharmacy technician, had died of colon cancer. Her father had raised her on a single piece of advice about American law, and we will come back to it. She was in Houston that August with a man she had been seeing for about a month. He was driving her white Chrysler Concorde. She was in the passenger seat. Late in the afternoon, he changed lanes, and to this day, she can't say whether he signaled. The lights came on behind them, and he pulled into a strip mall parking lot. The officer's report records that when he reached the car, he saw a needle in the ceiling lining. He asked the driver to step out. The driver got out. The officer leaned in over the driver's seat, looked around, and called to his partner. What the search turned up was this: a needle, a packet of BC powder, an over-the-counter headache remedy sold in every drugstore in the American South. And on the floor, a small white crumb. None of that is a crime. A crumb is not a crime, a headache powder is not a crime, and a needle on its own is not a felony. To make any of it into a charge, somebody has to say what the crumb is. In 2010, in one of the largest police departments in America, saying what a crumb was took about 90 seconds and cost $2. The officer went to the trunk of the patrol car and came back with a small plastic pouch. Inside the pouch was a glass vial of pink liquid. He opened the lid and dropped a piece of the crumb in. That is the entire procedure. No machine, no reading, no printout, no second opinion. There is a color. If it stayed pink, everyone could go home. If it turned blue, then Amy Albritton, the owner of the car, sitting in the passenger seat of her own vehicle, became a felony defendant. It turned blue. He waved the vial in front of her face. Then on the evidence submission form, in his own handwriting, he wrote down the weight of what he had found, 0.02 grams of crack cocaine. It was a figure written in ink at the side of a road, and it became the first official number in the file. Keep 2 numbers running through this film because the whole story sits in the gap between them. The first is the one the officer wrote down that afternoon. The second is the one a chemist would write down 6 months later. She was handcuffed in the parking lot. Both of them were taken in. And at the jail, before anything else happened, she was strip searched. Years later, asked about it, she answered in 7 words. Oh yes, with the bend over cough. She was booked into the Harris County Jail at 3:37 in the morning, 9 hours after the stop. In a property room, in a sealed envelope, sat a crumb nobody had examined with anything more sophisticated than a color. In the morning, she met her lawyer for the first time. His name was Dan Richardson. The court had appointed him, and he had a lot of clients that day. Everybody in that building does. He told her what she was charged with: possession of a controlled substance, crack cocaine, a felony. The maximum penalty was 2 years in a Texas state prison. By her account, he did not ask her what had actually happened, and he did not ask whether she believed she was innocent. What he told her was that the prosecutor had already made an offer, and it was for a great deal less than 2 years. Plead guilty, and the sentence would be 45 days in the county jail, of which she would probably serve about half. Now do the arithmetic she had to do, standing in a quarter in the clothes she was arrested in. Fighting it meant staying in custody because she could not post the bond. It meant a trial in a county she did not live in, hundreds of miles from her sons, against a police officer with a positive drug test and a signed report. It meant losing the job for certain, and the job was the apartment. And if she lost, it meant 2 years. Or she could say a sentence that was not true and be out in 3 weeks. There is a phrase for what happened next that makes it sound like a decision. It was not a decision. It was arithmetic, and the arithmetic only has one answer. A guilty plea in an American courtroom is not a shrug. It is a formal act. The defendant makes a series of statements that function as a confession and gives up a list of constitutional rights one at a time, out loud. Judge Vanessa Velasquez took her through the recitation. The record notes something the judge never asked about: why the woman in front of her could not stop crying long enough to finish a sentence. She was sentenced to 45 days. She served 21. And here is the finding that turns one woman's terrible week into a machine. When investigators later went back through these cases, the ones where the laboratory eventually said there had been no drug at all, they measured how long it had taken those innocent people to plead guilty. The median was 4 days. 58% of them pleaded guilty at the first opportunity they had, at arraignment, the very first time they stood in front of a judge. Then they measured the people who really had been carrying drugs. That median was 22 days. The innocent plead 5 times faster than the guilty. That is not a paradox, it is the system working as designed. If you are guilty, you have reason to wait. Evidence to suppress, a witness to challenge, time to bargain. If you are innocent and poor, waiting costs everything and buys nothing, because a positive test is already in the file and there is no laboratory report in there to argue with. This was not a Houston peculiarity. In 2011, a national study commissioned by the Justice Department found that prosecutors in 9 out of 10 jurisdictions surveyed accepted guilty pleas on nothing but the result of a field test. Not the laboratory. The color. There is one more thing in her file, and it belongs here rather than anywhere else. 2 years before Houston in Louisiana, she had pleaded guilty to a misdemeanor drunk driving charge. Her breathalyzer reading was 0.0. She pleaded guilty to that too. Same arithmetic, smaller scale, smaller machine. And it is why, when her father's line comes back, it lands the way it does. If the law said you had crack, he had told her, you had crack. She got out after 21 days with nowhere to go. She was fired. Her furniture and everything else she owned were carried out and put on the side of the road. So what is the thing in the plastic pouch? It is a glass ampule of a chemical called cobalt thiocyanate, and it is pink. Chemists have known for well over 40 years that when cocaine meets it, a blue color forms. That is the whole science. Drop the sample in, break the ampule, watch the color. It is that simple because it was designed to be simple. In 1973, the same year Richard Nixon formally created the Drug Enforcement Administration and declared, in his words, an all-out global war on the drug menace, 2 California inventors patented what they called a disposable comparison detector kit. A pouch, a vial. Open it, add the substance, seal it, break the glass, watch the colors change. An officer could carry a dozen in a glove box. It spread across the country almost immediately, carrying something more useful than accuracy, the appearance of science. A chemical, a reaction, a result. A laboratory in the palm of a hand. Within a year, the people whose actual job was measurement said so out loud. In 1974, the National Bureau of Standards studied the kits and wrote that they should not be used as sole evidence for the identification of a narcotic or drug of abuse. 4 years later, the Department of Justice reached its own conclusion. Field tests should not be used for evidential purposes. 1978. That is the year the American government determined, in writing, that this test does not prove anything. Amy Albritton was arrested on 132 years later. The problem is not that the test is fake. The problem is that the color is not exclusive. Cobalt thiocyanate turns blue for cocaine, and it also turns blue for more than 80 other compounds, among them methadone, certain acne medications, and several common household cleaners. One manufacturer keeps a list of more than 50 perfectly legal substances that will set off its own products. In one manufacturer's own kits, chocolate produces a color close to the one heroin produces. which is why the results are inadmissible at trial in nearly every jurisdiction in the United States. A prosecutor cannot stand in front of a jury and offer a color as proof. Read those two sentences together, and you have the whole film. The evidence is not good enough for a trial. It is good enough for a conviction. Because drug possession cases do not go to trial, police arrest more than 1.2 million people a year for illegal drug possession. Drug charges account for more than 1 in 10 of all county and state felony convictions, and at least 90% of those convictions arrive by plea deal. In Harris County, Texas, in this period, the figure was 99.5%. The courtroom where a field test would be thrown out is a room almost nobody ever reaches. The man who invented the test Houston was using has a name. L.J. Scott Jr. developed it in 1973 while he was working for the DEA, and in 1990 he founded his own company. The Houston Police Department became his longest-standing major customer. In 2014, the last year for which records were available, Houston bought 9,000 of his kits. And here's the part that is hard to shake. Scott knew a single reaction was not enough, so he had built a better version. 3 steps. Cobalt thiocyanate first for the blue, then hydrochloric acid, which turns the solution pink again and eliminates a whole class of imposters. Then chloroform, which splits a genuine positive into 2 clean layers. Blue below, pink above. Much harder to fool. When he started his own business, he went back to the single chemical interaction. The one-step test. The record does not say why, and neither will we. Asked about all of this, the man who made them said it plainly. No field test is fail-safe. Any field test can give you an erroneous result. Asked whether a laboratory ought to confirm every field test before anyone is convicted on it, he answered in 6 words. I would, but that's just me. His company's own website put the risk inside a parenthesis. It is possible, though unlikely, to receive a false positive result under certain conditions. And when reporters checked the labels, the 3 largest manufacturers carried no false positive warning at all. One of them added one only after it was asked. Everyone in this chain, the inventor, the manufacturers, the Bureau of Standards, the Justice Department, had been saying the same thing for 4 decades. Confirm it in a laboratory. In Amy Albritton's case, somebody eventually did. On the 23rd of February 2011, an analyst named Ottavia Barker sat down at the Houston Police Department Crime Laboratory with the evidence from a traffic stop the previous August and did what a field kit cannot do. She ran it through a gas chromatograph-mass spectrometer, an instrument that separates a sample into its components and identifies each one by its molecular fingerprint. It does not report a color. It reports what a thing is. The white powder came back first, aspirin and caffeine. The ingredients of BC powder. Exactly what the packet said it was. The needle had too little residue on it even to test. In the words of the investigation that later found this file, it was just a syringe. Then the crumb. The fragmentation pattern did not match cocaine. It did not match any other compound in the laboratory's database. And that database is enormous. It was not a drug. It did not contain anything mixed with a drug. It was, the reporters who read the file wrote, a crumb. Food debris, perhaps. On the examination sheet, Barker wrote the finding in the laboratory shorthand. N.E.M. No acceptable match. And then N.C.S. No controlled substance identified. And she wrote the weight. The officer at the roadside had put down 0.02 grams. The scale in the laboratory measured what was left at 0.0134 grams. About the same, Barker noted, as a tiny pinch of salt. That is the object at the center of this story. A pinch of salt's worth of something that was not a drug, on the floor of a car she was not driving, in a state she did not live in. By the time that report existed, Amy Albritton had been out of jail for 5 months. She had lost her job, her apartment, and her furniture, and she was a convicted felon in the state of Texas. Then nothing happened because of a detail so mundane, it is almost the whole scandal. Laboratories rarely notify officers when a false positive comes back. The report was filed. It was correct. It was 6 months late, and it was addressed to nobody. She spent the next years learning what a felony record does to an ordinary working life. A convenience store with hours that changed every week. Bartending. waiting tables, eventually managing property again in Baton Rouge for a landlord whose buildings nobody else wanted, at a wage that did not include an apartment. Tips included, she was earning about $15,000 a year. She liked her coworkers. She impressed her bosses. She could not rent in her own name because no landlord takes a drug felon. Now the story stops being about one woman. In Harris County, the district attorney's office had begun to notice something in its own paperwork. A case would close with a guilty plea, and then, weeks or months later, a laboratory report would arrive saying the evidence was not what the defendant had confessed to possessing. The office had a name for the mismatch. It called them variants. District Attorney Devin Anderson hired a former prosecutor, Marie Mounier, to go back through the files and count them. The Conviction Integrity Unit, run by a prosecutor named Inger Chandler, took what she found. Between January 2004 and June 2015, the office had failed to correct 416 variants. Every single one had ended in a guilty plea. Some were ambiguous, positive for the wrong drug or the wrong weight, or too little left to analyze at all. But in 251 of them, the result was not ambiguous in the slightest. The laboratory's finding in the office's own file was the same 3 words that were on Amy Albritton's sheet. No controlled substance. 301 of the 416 had begun as arrests by the Houston Police Department. Of those 301, 212 were built on evidence the laboratory determined was not a controlled substance. All 212 of those people pleaded guilty. 93% were sentenced to jail or prison. 50 of them had no prior drug conviction of any kind. 2 more numbers belong here, without commentary. 59% of the wrongfully convicted were Black, in a city whose Black population is 24%. And 63% of the cases involved less than a single gram of evidence. Less than a gram. That is the entire category. Not kilos in a trunk, crumbs, residue, powder in a fold of paper. And notice who found this. Not a defense campaign, not a newspaper, not a federal investigation. The office that won every one of those convictions went back through its own files and counted its own errors. The institution that convicted them is the institution that found them. What it did next was slower. By the summer of 2016, the Integrity Unit had struck 119 no-controlled substance convictions from the record. At least 172 more were still standing. One of the letters had gone out on the 29th of July 2014. It was a form letter. Mounier was sending hundreds of them, and it opened with the salutation, "Dear Sir" or "Madam." The body of it was not generic at all. It told the recipient that the Harris County District Attorney's Office had learned the drug evidence in her case was not a controlled substance. And then this sentence, accordingly, "You were prosecuted for a criminal drug offense and convicted in error." It was posted to the address on her driver's license. She was not there. That address was the apartment that came with the job, and the job had ended the day she pleaded guilty. The letter telling Amy Albritton she had been convicted in error was mailed to the home the conviction took away from her. She found out from reporters years late. Her answer was 6 words. "I knew it. I told them." Her conviction was eventually set aside. In March 2016, a reporter sat down with the man who had run the Houston Police Department through all of this. Charles McClelland had been his chief of police, and he was asked about the $2 kits his officers carried. He did not defend them. What he said was this: "Police officers aren't chemists. We shouldn't be doing field tests on the hood of patrol cars." That is a chief of police on the record saying the procedure that convicted 212 people in his own city should never have been performed by his own officers. He went further. If he had known about the false positives his department was generating, he said, he would have ordered a halt to all field testing across the entire force. If he had known, 9,000 of those kits a year went out of that department's supply room. One was opened at the side of a road in August 2010 and held up in front of a woman sitting in her own car. The laboratory results had been coming back for over a decade. Nobody told the chief because the system contained no step in which anybody had to. So what changed? In 2015, District Attorney Devin Anderson issued the reform that should have existed for 40 years. Her office would no longer take a guilty plea in a drug possession case before the laboratory had issued its report. She described what had happened in her county as a breakdown at every point in the system. Read the timing of that rule, and the trap is visible. Laboratories typically issue a report in about 2 weeks. Defendants usually see a judge within 3 days. For decades, the plea had simply been faster than the truth. Anderson's rule made the truth go first. In December 2016, a Texas state panel, the Timothy Cole Exoneration Review Commission, 11 members including legislators, a criminal appellate judge, prosecutors, police officers, and forensic scientists, recommended that the state require laboratory testing in every case built on a drug field test. Its own words, requiring laboratory testing of all drug field tests will reduce the risk of wrongfully arresting and convicting an individual of being in possession of a controlled substance. The following year, the Texas legislature passed House Bill 34, titled An Act Relating to Measures to Prevent Wrongful Convictions, effective September 2017. Section 8 of that act directed the Texas Forensic Science Commission to study drug field test kits, their quality, accuracy, and reliability, and the common problems with them, and report back by December 2018. A study, not a requirement. The state that produced hundreds of these convictions answered its own commission by commissioning more reading. In July 2017, the Houston Police Department itself did stop, ending its long-standing practice of using the $2 kits to make drug arrests. Chief Art Acevedo said officers would rely instead on their own expertise. They have, he said, a wealth of training and experience into what narcotics look like, what they feel like in terms of the packaging, the color, the appearance. And the stated reason was not accuracy. It was officer safety, the fear that handling street fentanyl to run a color test would poison the officer running it. The kits stopped in Houston because they had become dangerous to police, not because they had become dangerous to everybody else. Elsewhere, the count kept climbing. By 2020, more than 250 wrongful convictions had been overturned in Houston alone, and prosecutors in Las Vegas and in Multnomah County, Oregon, had begun vacating their own. Judges began to move slowly. In 2018, in Imperial County, California, Judge Christopher Plord ruled that one widely used brand of field test does not meet a scientific admissibility standard. In 2021, a Massachusetts judge named Brian David ordered the state's Department of Correction to stop using its kits on prisoners' mail, calling the practice arbitrary and unlawful guesswork, and he had a measurement to work from. Over a single year, laboratory analysis of that mail found 38% of the items testing positive contained no drug at all. One manufacturer's own answer is the one that has always been available to all of them, and it is technically correct. Field tests are specifically not intended to be used as a factor in the decision to prosecute or convict a suspect, which raises the only question that matters. If nobody intends them to convict anyone, why do they? Here is the answer. The kits were never withdrawn. No federal agency regulates their use. There is no national training standard for the officers who carry them, and many get little or none. And nothing in American law required a laboratory to confirm a field test before a person pleaded guilty on it. Meanwhile, the machine kept running. In January 2024, the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania measured it. Of the more than 1.5 million drug arrests made in America every year, roughly 773,000 involve a color-based field test. Roughly 30,000 people a year are falsely implicated by one. 90% of prosecutors still accept a guilty plea without laboratory confirmation. 46% of laboratories do not run the confirmation at all once a plea has been filed. The case is closed and the truth is no longer needed. And Black Americans are arrested on a false positive at roughly 3 times the rate of white Americans. The study's lead author put the design fault in one sentence. Presumptive field drug test kits are known to produce false positive errors and were never designed or intended to provide conclusive evidence of drug presence. 30,000 people a year. That is not a backlog of old cases. That is this year and next year. Then this spring, one state did something. On the 26th of March 2026, the governor of Colorado signed House Bill 26-1020, passed 65-0 in the House and 33-0 in the Senate. Police there may no longer arrest a person for misdemeanor drug possession, where a color change field test is the only basis. They must issue a summons instead. Before a defendant pleads, the court must tell them the test has a known error rate. And the right to demand a laboratory is written into the statute. Colorado is the first state to put any of that into law. 53 years after the patent, 48 years after the Justice Department said these tests should not be used for evidential purposes, and 10 years after an investigation counted the convictions in one Texas county. One state out of 50. So what did the set-aside fix? Asked that, she said, no, you're not ever free and clear of it. It follows you everywhere you go. A vacated conviction does not give back a job, or an apartment that came with the job, or the furniture carried out to the curb, or the years at $15,000, or the applications declined by landlords who ran a background check and did not read to the end. It does not unsay the statements she made in that courtroom while a judge waited for her to stop crying. And it does not undo what she had been taught before any of it began. If the law said you had crack, her father had told her, you had crack. Go back to the object one last time. A crumb on the floor of a car at the side of a road in Houston. An officer looked at it and wrote 0.02 grams. A chemist put it on a scale 6 months later and wrote 0.0134 grams. A pinch of salt, and beside it, 3 words, no controlled substance. Between those two numbers sat 45 days. 21 days served, a job, a home, and a felony record for life. Nobody was disciplined. Nobody lost a job over it except her. No court ever found that the officer did anything wrong. That is the point, and it is harder than a villain would be. Nothing here required anyone to break a rule. Every person in the chain did what the system permitted, and the system permitted this. Somewhere tonight, an officer will open a small plastic pouch at the side of a road, drop something in, and watch the color. It costs $2. It is the same chemistry it was in 1973. And whoever is in that passenger seat will find out, the way Amy Albritton did, that in the space between a color and a laboratory, there is room for a whole life to fall through. If you think nobody should be a felon before the evidence has been tested, hit like and stay for the next one, because the machine in this story is still running.